This is session 3 of 5 and will cover the legal implications of climate-related governance failures. Sarah Barker will be talking through board responsibilities. Stakeholder dialogue on climate has increased tremendously over the years since the Paris Agreement was implemented in 2015. The emphasis on climate action has come to the fore, and many companies are putting forward ambitious climate plans, looking at how they will address both risks and opportunities related to limiting temperature rises to under 2 degrees versus pre-industrial times, and preferably hitting a more stringent target of limiting temperatures to 1.5 degrees Celsius. But that means that it comes with responsibility. And what are the legal implications related to that? Well, companies, as they're setting out climate plans, are being held to account over the progress that they're making on delivering those plans. And they're also increasingly held to account over whether those climate plans are in actual fact aligned with that temperature trajectory that we want to limit. That becomes a stewardship issue and a responsibility for board members themselves to demonstrate the progress against the plan, but also take accountability and responsibility for what the plan is putting in place in the first place. So to take us through that dialogue, we're going to listen to Sarah Barker. Over to you, Sarah.
I have the honour of explaining to a bunch of directors why climate-related governance is such an important issue for you. And I suppose it can be summed up in the maxim that nothing focuses the mind like the spectre of personal liability. When I first started as moving across from being an antitrust lawyer to being a full-time climate risk governance lawyer, the first question I was always asked by in-house counsel and by directors themselves is, show me the case. Show me the case rather than the theory. So today I'm going to talk you through exactly that. We now have a significant uptick in trends associated with the number of climate-related claims filed, not only against corporations, but their directors. And this is in jurisdictions, of course, the US, where you would expect being a very litigious jurisdiction, but not exclusively. Increasingly, we're seeing claims being filed in other jurisdictions, both civil and common law, from Australia to the United Kingdom, to Canada, to South Africa, to the EU. I also want to impress that this is not a matter of litigation that is arising due to a regulatory breach. It's not litigation arising because a large emitter has failed to comply with their obligations to mitigate their emissions, for example. And in fact, there's almost an inverse relationship between the volume of emissions-related legislation in a jurisdiction, as you can see there, and the frequency with which claims are filed against companies and directors. So today, I just wanted to talk you through 3 things. First of all, litigation against your institutions. Secondly, against institutional directors. And finally, trends in litigation against borrowers and investees, which of course can have secondary and tertiary flow-through impacts for financial institutions and for financial stability within an economy more broadly. So litigation, as it manifests against financial institutions and their directors, is primarily a function of economic transition risks associated with climate change, although of course it can also manifest in the physical risks associated with climate change. Here I've got a copy of a report that we originally did for the European Commission back in 2017, when we actually looked at the role of litigation as a material driver and or consequence of the transition to a low carbon economy in Europe. And a number of the categories that we analysed there squarely related to exposure to claims by financial institutions and their directors for a failure to adapt to the foreseeable impacts of the transition to a low carbon economy. And here very much we're looking at claims for misleading disclosure or securities fraud, as it's called in some jurisdictions, but also a breach of a director's duty of due care and diligence. Because one of the corollaries of the shift of climate change from being an environmental lefty hippie greenie issue to one that presents material financial risks within mainstream investment horizons is that it does open up the entire suite of commercial litigation and undeniably renders climate change an issue that must be considered as a foreseeable financial risk consistent with the best interests of an organisation. Now, since that time, these claims are no longer theoretical. So increasingly, we are seeing live examples of cases both against institutions themselves and against their directors and officers. So here I've got an example of a case filing against a $50 billion Australian, so about $40 billion US / Euro pension fund, Rest Super. A beneficiary of that fund has brought a claim against the trustee, alleging in essence that the trustee has breached its duty of due care and diligence by failing to integrate climate-related financial risks into their investment strategy on behalf of that beneficiary. Now, this case is notable because it will run. It is set down to run to trial this November. It was certainly the first of its kind around the world, and it sent reverberations amongst the pension fund directorship community here in Australia, of which I am one, certainly when it was filed. More than that, and in addition to that, the same law firm that is behind the Rest filing has more recently filed a claim in relation to sovereign bonds issued by the Commonwealth Government here in Australia. In late July, a claim was issued that alleges that the Commonwealth Government acted in a way that was misleading or deceptive by failing to disclose climate-related financial risks in their investor statements issued in relation to sovereign bonds. Now, it's very interesting that this related to disclosures for vanilla bonds. It wasn't the case that the government had issued a green bond and an allegation of greenwashing was levelled at it. This is squarely the issue of a vanilla instrument and an allegation made that given the materiality of climate-related financial risk to a sovereign, that the elements of the impact of climate change should have been disclosed to investors in that case. Interestingly, this was actually an argument that we first saw being run by the carbon majors as part of the series of cases that's currently ongoing in the US, where a number of municipalities are running claims against the carbon majors, seeking damages for the cities having to adapt to the physical impacts associated with climate change. In one of the cases associated with that series, an argument was actually run by the carbon majors that if climate change was such a material risk for the municipalities that were suing it, then they would have themselves needed to disclose climate-related financial risks in their own municipal bond disclosure documents. So it's an additional element that needs to be considered now for any financial institution issuing any kind of debt instrument. How robust are our procedures for the information gathering, verification and disclosure of climate-related financial risks, and how they may impact on the financial security associated with the bond? One more interesting observation in relation to this case, particularly in relation to directors. In addition to the claim that the Commonwealth Government had acted in a misleading manner, the plaintiffs have also joined two officers, two individuals associated with the bond issue, the Secretary of the Treasury and the CEO of the Australian Office of Financial Management, alleging that as officers responsible for the organisations making the bond issue, that they breached their duties of due care and diligence in allowing the Commonwealth to issue investor statements that were misleading. So the bar on this just keeps rising for directors. If we're looking at, well, what does due care and diligence mean for us? What do we need to do? From a very first principles basis, we can think about, well, we're tested against or tested to the standard of a reasonable director. What would a reasonable director do or have done in similar circumstances? It's very important, though, to note that the courts in recent times have expected far higher standards of professionalism and diligence from directors in reaching that standard of care. And really, if you think about, well, what is a reasonable director? What do they hold themselves out to be expert in? It really is risk management, strategy, and governance. So the question needs to be asked, what would a reasonable manager of risk and strategy and governance have done in relation to climate change in this circumstance? It's also very important to note that by the standard of a reasonable director, we don't mean the standard of care of an average director. The reasonable director is often held to a standard that's, in hindsight, more akin to standards of best practice than average. The question for us now in a climate context is, at what point does the standard of care actually require directors to ensure that their entities are complying with the TCFD? At what point does the standard of care demand governance that at least considers the trajectory of a company on a net zero strategic pathway? Now, these are live questions for the law at the moment, and I should note that the law is itself not concerned to require a particular outcome of boards. It's really concerned with the robustness of the decision making that sits underneath the decision. But nevertheless, it does remain a live issue for us as directors. At what point will the law oblige us to be considering whether or not we require a net zero strategy in order to be discharging our obligations to pursue the best interests, best financial interests of our company? The last thing that I flagged was the potential for litigation against borrowers and investees. Here I'm going to point to a recent report by the Commonwealth Climate and Law Initiative, for full disclosure of which I am a director, in which we looked at a related question on the different categories of liability exposure for financial institutions associated with biodiversity loss and ecosystem services. And you can see there that the categories of litigation that are relevant to potentially your borrowers or investee companies, and therefore that might impact on the financial stability of an institution itself, are very diverse across physical ecosystem impacts, transition risks, economic transition risks, and also in the category of misrepresentation. So given the time available tonight, I would, or this morning, wherever you're located, it's 10:30 at night for me, I would commend that report to you. In terms of examples of where we're starting to see those claims really starting to hit home, I think there is no better example than the series of cases we're seeing coming out of the UK, the EU, and the US in relation to judicial appeals against development approval decisions. So there've been a series of cases in relation to airport third runways, for example, in relation to motorways, and in New York in relation to gas pipelines, where the primary consideration was whether or not the decision maker had actually turned their mind to whether or not the development approval was consistent with the jurisdiction's net zero emissions target. So in the case of the Heathrow third runway, for example, the government's approval to allow that runway to go ahead was held to be beyond power, ultra vires, because of the fact that they had not reconciled the potential for that project, if approved, to be consistent with the net zero emissions target, as it was then prior to their law in place in the UK. So it's another layer of consideration that lenders now need to go through when considering the bankability, so to speak, of a project. Now, picking up on Karina's comments at the start of the session around the concern of members to ensure that they know what questions to ask of management, I will leave you with a set of questions for you to take away to be asking management in relation to your oversight of how well management is assessing and assuring exposures to climate-related financial risks, procedures for disclosures, and another issue that is material that we haven't had time to touch on tonight, which is contractual risk management and procurement. So I will stop sharing there and hand back to Daniel, or am I handing directly over to Paul?
Yeah, thank you, Sarah. Maybe I'll pick up one question that came through because it's so specific to you. The question is, how many of the filings actually resulted so far in penalties versus have been dismissed? I know we're very early in this discussion, but do you have a sense of sort of outcomes?
Yes. There has only been one case so far against a director, and not of a bank, of an oil major in the United States, where the finding has been that the director is not guilty. Every other case remains on foot or has been settled in advance of going to trial. So I certainly wouldn't take the absence of a judgment that specifies at this stage that a director has acted in breach of their duty of due care and diligence, or has acted in a way that constitutes security fraud to be evidence of the fact that this is not a live risk, because there are dozens of cases that remain on foot. And of course, most of these kinds of claims, particularly shareholder class actions, will settle prior to reaching trial in any event.
And one other question from me, I guess a number of directors and companies will question when asked themselves, is no disclosure better than poor disclosure, or is actually disclosing the right answer and then I evolve? But I think as soon as you obviously start to publish, you make yourself a lot more attackable.
If I had $1 for every time I was asked that question, Daniel, I would be a very rich lady. In relation to climate change, like no other area, there is a need for fulsome disclosure, because by remaining silent in relation to the climate-related financial risks that impact on your institution, what are you representing? You're representing either that it's not material for you, A, or B, that you have analysed the risk thoroughly and that you have concluded that it doesn't warrant disclosure. Now, either of those cases is going to be highly unlikely for a financial institution in a modern economy. And so it's actually less of a risk in this case for directors to ensure that their organisations are disclosing and particularly publishing stress testing and scenario analysis with regard to the TCFD framework. And one additional issue we haven't had time to talk about tonight is, of course, the increasing noises from accounting standard setting boards indicating that that analysis should also be integrated and applied across into the accounting estimates in the balance sheet. So I would definitely say no disclosure is a huge risk, and fulsome disclosure is actually lower risk than you may anticipate because investors understand these risks anyway. So you're not telling them anything that they don't know.
Thank you, Sarah. Again, a lot of useful and interesting messages in this session. I especially thought that the point on disclosure and the legal implications of climate-related disclosures failures is very interesting. A company's choice of no disclosure due to the complexity and uncertainty of the implication of climate risk on the business is not a solution, as no disclosure can be interpreted as an indication that the company faces no risk or an immaterial risk on the matter, which is hardly ever the case. And this could be construed as misrepresentation, which may open up a significant legal risk and responsibility also for the board. So I think it is important that as directors, we reflect very carefully and engage with management on how to address the appropriate level of disclosure as well as governance framework. Also in the understanding that this is a journey which needs to involve an open and transparent dialogue with stakeholders and the broader group of stakeholders as appropriate, as indicated by Sarah in this example that she has quoted. I also like to focus on directors' duties and responsibilities on this matter, and especially focus on a point that is also at the core of what Chapter Zero and the Climate Change Initiative do. One of our duties as directors, albeit somewhat implicit, is also to keep ourselves informed of developments that impact the business, to understand the evolving risks and opportunities the company faces and engage with management to act on those issues. Climate change is an evolving discipline, still fraught with significant uncertainty, which require technical expertise. But not knowing or not understanding the implication of climate change on the business is not a sufficient justification and certainly not a fulfillment of our duties as directors. It is therefore important that as directors, we also reflect on how we can build that knowledge and understanding. For example, to what extent this requires an adjustment of the board induction and training plan, or whether it even requires a scientific advisory board to support the main board in the fulfillment of its duties.